Like that? All right.
And my understanding is, I guess at 7-Elevens, if it's, they have it at 7-Eleven, you have to show, it's the barcode triggers.
Right. Just like you go to a grocery store, the barcode would trigger that it's an alcoholic beverage.
Check ID.
Right. So I'm still trying to figure out the purpose of banning it.
You know, I can see limiting the amount of caffeine in it to the same as so you wouldn't get any more than you would get from a Coke. But I also question how come they're just targeting malt beverages, because there's also vodka drinks on the market that have caffeine in vodka.
That's true. Interesting.
So it's like it's like the animal protection stuff. You know, pick one little thing and focus on that. You know.
Well, I think they probably felt they had an easier case because of the bans last year.
Yeah, that's true.
But those bans, though, then you said they pulled it themselves, though.
They pulled it themselves.
One more.
Good morning. We are waiting for one more member, and then we will have a quorum. And here she is. All right, Madam Secretary, would you please call the roll?
Cotto.
Cotto is here.
Anderson. Blakesley.
Here.
Chesbro. Cook.
Here.
De Leon. Evans. Galgiani. Hall. Hernandez. Hill.
Here.
Jeffries.
Here.
Liu. Ma. Mendoza. Nastandi. Perez. Portantino. Silva. Torres. Tarico. Tran.
Evans is here. All right, a quorum has been established. Members, we have 11 items on our agenda. The order will be Ira Ruskin, followed by Assemblymember Nava, followed by Jim Bell, and Mr. Blumenfield at this point. Yes, and then we'll get the consent calendar out of the way first. Let me just make an announcement to everyone here, members. You know that the Speaker has requested that we schedule oversight hearings during this legislative year. Every committee, I think, is doing that. We have received some recommendations from members and other people about the topics of those types of oversight hearings. And let me just give you some suggestions or some ideas about the suggestions that have been made. And then I'd like to ask all of you members to see if you have any other suggestions or ideas about oversight hearings, and we'll schedule those during the portion of the year. One recommendation was licensing, enforcing, and regulation of alcoholic beverage sales in California. A second one was the current, future, and status of horse racing in California. A third one was issues, trends, and oversight of outdoor advertising in California. We have one bill that deals with that one today. Another one was internet poker and internet gaming as a follow-up to what transpired with the Senate hearing, and disaster and emergency preparedness. So, members, if any of you have any suggestions about any other topics that you would like for us to consider during this year, please let me know, and we'll add those to the list. and then we'll take it from there. All right, members, can I get a motion on the consent calendar, please? Moved by Torres, seconded by Chesborough. Please call the roll. Any discussion, though, by the way, on the consent? Yes, item number 2, for your, in case you want to make note of these items, number 2 by Smythe, item number 3 by Chesborough, item number 4 by Mendoza, AB 1860 by Tom Berryhill, and AB 2021 by Fletcher. By the way, Smythe was AB 1643, Chesborough was 1649, and Mendoza was 1773. Questions on those items? If not, please call the roll.
Koto.
Koto, aye.
Koto, aye. Anderson. Blakesley. Blakesley, aye. Chesborough.
Aye.
Chesborough, aye. Cook.
Aye.
Cook, aye. De Leon. Evans. Evans, aye. Galgiani. Hall. Hernandez.
Aye.
Hernandez, aye. Hill.
Aye.
Hill, aye. Jeffries.
Aye.
Jeffries, aye. Liu. Ma. Mendoza. Nastandi. Nastandi, aye. Perez.
Aye.
Perez, aye. Portantino. Portantino, aye. Silva. Aye. Silva, aye. Torres. Aye. Torres, aye. Tarico. Tran. Aye. Tran, aye. Zach.
Okay, members, I see about an hour and 15 minutes worth of work today. So we'll try to move this as quickly as we can. If you have any thoughts about slowing it up, please advise me. All right, first item, bill today, I'd like to call on the Honorable Ira Ruskin, AB 2733. Mr. Ruskin, it's a pleasure to have you here.
Is it on now? There it is. I'm here to present AB 2733. The Board of Equalization has the authority and the responsibility of revoking or suspending the license to sell cigarette or tobacco products when appropriate. When the suspension or revocations are issued, the licensee must cease the sale of cigarettes or tobacco products, and it's also requested that such products be removed from the retail sales area from display. But there are some serious problems that have resulted because of the lack of clarification of statute. Firstly, while retailers are requested to remove items from display, often they do not. And in cases of undercover agents or in other cases, sales sometimes occur. The retailer usually uses the excuse, it wasn't really a sale, it was a mistake. The employee shouldn't have done it, but they did it, and it's not a real violation. Secondly, often suspended or revoked licensees use cigarettes or tobacco products as gifts. And when cited for this, they say, well, it's a gift, it's not a sale. But a gift has value. The gift is done to leverage a value in return for the value of the gift given. This is a problem. So what my bill will do is very simple. It will state that you cannot display cigarettes or tobacco products if your license is suspended or revoked. It will clarify the gifting issue so that there is no excuse, and it will also require posting of the fact that the license is suspended or revoked on the premises, so there is no further ambiguity. I ask for your aye vote. I'm happy to take all the amendments that you and your committee have suggested. We're working on them with your staff. We will take them in judiciary if that's okay with you. And with me today are Cindy Wilson and Richard Parrott of the Board of Equalization, if you have questions.
I'll move the bill, Mr. Chair.
Bill's been moved. Do we have a second?
Second.
Moved and seconded. Excellent presentation, by the way.
Thank you.
Please, testimony and support.
Good morning. My name is Cindy Wilson, and beside me is Richard Parrott from the Board of Equalization. As the Assembly member mentioned, we're the sponsors of the bill, and we were here to answer any questions you may have had. Thank you.
Anyone else? Any other testimony in support of the bill? Is there any testimony in opposition to the bill? We have a question from Vice Chair,
Acting Vice Chair.
Acting Vice Chair.
Acting Vice Chair.
Assistant Acting Vice Chair.
Two of the three goals of the proposal, I think I could support the cannot display and posting of the suspension. The gifting issue, however, raises a concern for me. Not so much gifting, but my curiosity is more about what do you do with your inventory as a retailer, and you have a significant inventory and you get shut down for whatever variety of reasons. What is it that you can legally do with the inventory if you can't sell it and you can't give it away?
Well, first I would say that the licensee should have thought of that before they did whatever they did to merit their license being suspended or revoked. But in addition to that, I'll ask the board to respond. In this case, it's the gifting that has been considered is where it leverages some value. But
this is Richard Parrott. A retailer could, during the suspension, just lock up the product until the suspension is served. They could store it in a storage room or even in a storage facility. And then once the suspension is done, they're allowed to sell again.
Okay. What about a revocation?
A revocation, what we've seen in the past is if a revoked licensee is allowed to sell that business to another entity that's at what they call an arm's length transaction, meaning it's not a related company or entity, typically we see that product is then taken over by the new owner. That's what we've seen in the past. Meaning it's part of the business transaction, but that's typically what we see in cases of revoked licenses.
So it would be permissible under the provisions of this bill if someone has their license to sell tobacco revoked for them to sell their tobacco to a new buyer? Another retailer?
I think we'll need to check on that. That's what we've seen. I don't know. I think we'll need to look at that.
That'd be my only concern, and it's not a concern of objecting to their ability to do that. It would be essentially a double jeopardy or a double whammy. One, you'd have the impact of having your license revoked, justifiably, I assume. But then the economic impact that would hit them even further, I would think that we would want to be able to allow the product to be sold to somebody legally above board, not backroom, black market deals, and, of course, collect the revenues of that sale for the state. So I think it's important that be considered, and I address that to the author. Something to consider is, do you want to force a black market environment, or do you want to allow them a way to unload their product legally and the state know about it?
Yeah, I understand the direction of your question, and it's a good question. We'll look into it and take it under consideration.
Thank you.
Assemblymember Torres.
I don't have a question. I just want to thank the author for bringing this bill. There are many of these places around my district that have been closed. There is no way for the public to know that their license had been revoked. So this is one way that the community can be part of the solution of enforcing our laws. Thank you.
Thank you.
No other questions or comments? Would you like to close, Mr.
I ask for an aye vote.
The motion is members do pass and refer to the Assembly Judiciary Committee.
We'll look into that.
Madam Secretary, please call the roll.
Cotto?
Cotto, aye.
Anderson? Blakesley? Aye. Blakesley, aye. Chesbro? Aye. Chesbro, aye. Cook?
Aye.
De Leon? Evans? Galgiani? Galgiani, aye. Hall? Hernandez? Aye. Hernandez, aye. Hill? Aye. Hill, aye. Jeffries? Aye. Liu? Ma? Aye. Ma, aye. Mendoza? Nastandi? Perez? Aye. Perez, aye. Portantino? Aye. Portantino, aye. Silva? Torres? Aye. Torres, aye. Tirico? Tran? Aye. Tran, aye. So, 12.
Yes, 12 votes. Your bill is out.
Thank you very much.
Thank you very much, Mr. Ruskin. Next item, members, is AB 2496, cigarette and tobacco products by Assemblymember Nava. Pedro, thank you very much for being here. It's always a pleasure to have you out of committee.
I appreciate the invitation. Consent would have been nice. I'm here to present on Assembly Bill 2496, the Tobacco Damages Recovery Act. I want to mention we've been meeting with all of the stakeholders and the committee on this bill. There are some technical amendments that will be taken in the Judiciary Committee. This bill will greatly enhance our statutes concerning the Master Settlement Agreement and related statutes. In 1998, the Attorney General of California and 45 other states agreed to settle more than 40 pending lawsuits with the nation's 4 major tobacco companies. The suits were brought to recover the public costs of treating smoking-related illnesses. The settlement is now known as the Master Settlement Agreement, or the MSA. Under the MSA, the state is required to diligently enforce its smaller, non-participating manufacturers, who are also called NPMs, escrow statute, under which the NPMs that are not party to the MSA are required to set aside funds to offset future liability to the state for the public costs of treating smoking-related illnesses. According to the terms of the MSA, California must diligently enforce both components of the MSA, including the payments from the larger manufacturers and escrow deposits from the smaller folks, so that we recover the monies lost to medical treatment. In addition, if the state does not fulfill its obligation to pursue the NPMS, the state's revenue stream from the MSA may be jeopardized. Recently, Virginia and 4 other states have enhanced their enforcement legislation, closing loopholes that have allowed NPMs to evade escrow payments, thereby raising the bar on the standard for diligent enforcement against NPMS. There's a risk that if California fails to keep pace with Virginia's enhanced escrow statute, the major tobacco manufacturers will be able to argue that California is not diligently enforcing against the smaller entities and can use that to support a reduction in their payments made to the state. This bill is sponsored by the California Department of Justice and supported by the American Lung Association, and I note there is no opposition. I ask you to join me in supporting this bill, which will close loopholes in current statute and allow California to recover damages agreed to by the tobacco companies, and we have witnesses in support.
Good morning. My name is Mark LaForest. I'm the Director of Legislative Affairs for the Attorney General's Office. With me is Bill Suhu from the Attorney General's Tobacco Litigation and Enforcement Unit. The Attorney General's Office is the sponsor of this bill. We regard this as an important effort to ensure that enforcement of the Master Settlement Agreement is conducted diligently. It is important that the state enforce against non-participating manufacturers to ensure that their escrow payments are made as appropriate to the escrow account. The enhanced enforcement provisions will allow us to close loopholes and do that. It's also important that non-participating manufacturers are paying their appropriate taxes as required by state law. Mr. Suhu is here to talk about some of the practical problems that we've had in enforcing the statute in recent years.
Good morning. My name is Bill Suhu. I'm a Deputy Attorney General in the Tobacco Litigation and Enforcement section of the Attorney General's Office in the Department of Justice. As Mark says, the Department of Justice is a sponsor of this bill. My section and I enforce the Master Settlement Agreement against the participating manufacturers, as well as the NPM escrow statute against non-participating manufacturers, and the Tobacco Directory Law against all tobacco manufacturers. We and the other 45 states that signed the Master Settlement Agreement have been diligently enforcing those laws for 10 years now. In his statement, my colleague Mark LaForestier has highlighted some of the enhanced enforcement authority that we're asking you to give us by enacting AB 2496. In turn, Mark has asked that I provide you some concrete examples of why California should adopt these enhancements, most of which other states like Virginia, Kansas, Oklahoma have already adopted. In substantial part, the states have adopted these enhancements to address the problems of enforcing the Master Settlement Agreement, the state NPM escrow statute, and the Tobacco Directory Law against foreign tobacco companies. The enforcement enhancements in AB 2496 are needed because many foreign tobacco manufacturers have intentionally and unscrupulously created sham tobacco companies as a means for evading MSA payments and NPM escrow deposits, and often state taxes as well. As a specific and notorious example, the states have determined that a tobacco company in the Philippines was evading NPM escrow deposits by creating a new sham tobacco manufacturing corporation each year. It also had each newly created sham corporation make a new cigarette brand each year. The new but sham corporation then simply neglects making the annual NPM escrow deposits when they ultimately become due under the statute. Only when the states later investigate the failure to make the deposits do we learn of the sham. Under this scheme, a new tobacco company and a new brand is created at a new address and with new company officers every year in order to continue to evade the required NPM escrow deposits. In addition, because it never intended to make the required escrow deposits later, the sham corporation is able to undercut the prices of the cigarettes of their legitimate competitors, who must incorporate their MSA payments or escrow deposits into their prices. Through such predatory pricing, the sham corporation makes cheap cigarettes available in California. And as you know, cheap cigarettes often end up in the hands of our kids. It took about 3 or 4 years for the states to figure this scam out because the Philippines perpetrators actually completed and filed the forms, paid the fees required by the Philippines government to create a legitimate corporation. That way, the perpetrators knew that the Philippines government would tell the states that asked that the corporation was a legitimate corporation. Tobacco companies in other countries, including, for example, China, India, and Paraguay, also employed sham tobacco companies and new cigarette brands to evade making the required MSA payments or NPM escrow deposits. Even if a state manages to uncover the true identity of a scamming tobacco company and then successfully obtains a state or federal court judgment against a company, it is virtually impossible to obtain payment on our judgments from the foreign tobacco company. This is because the courts in the tobacco company's own country will not enforce a United States court judgment against companies in their country. As another example, let me tell you about my enforcement efforts against China National Tobacco, the largest tobacco company in the world. I have obtained 2 California court judgments totaling over $9 million against China National Tobacco for failing to make the escrow deposits required by the NPM escrow statute. As you know, China National Tobacco is owned by the Chinese national government. In my attempt to enforce these judgments, it took about a year to find someone brave enough to serve our judgments on the tobacco company of the Chinese Communist government, and another year to complete the service according to the procedure and in the manner required by the governing international treaty between the United States and China. When the judgments were finally served successfully as required by treaty, China National Tobacco then nevertheless refused payment of the judgments outright on the grounds of sovereign or government immunity. China National Tobacco claimed immunity because they were Chinese government entities. Under the legal doctrine of sovereign immunity, any payments by foreign government entities would have had to have been specified in a treaty negotiated between the United States State Department and the Chinese Communist government. I hope these examples help explain why we and other states ask that these foreign manufacturers, as a condition of selling cigarettes in our state, be required, among other things, to 1, consent to the jurisdiction of the California courts to enforce the Master Settlement Agreement and the escrow laws that apply to NPMs, 2, waive any sovereign immunity defenses, 3, post surety bonds to guarantee the payments required if our office determines that they pose an elevated risk, including being a new tobacco company or a tobacco company asking to sell a new cigarette brand in California. And 4th, to further help enforcement against scamming tobacco companies, we ask that the sales reported in the tax returns filed by licensed distributors with the Board of Equalization be admissible as evidence and presumed to be accurate. In closing, I would like to point out that AB 2496 is not just about MSA enforcement or NPM enforcement. At the request of the Board of Equalization, AB 2496 also provides relief for retailers and distributors who find themselves with brands of cigarettes and cigarette tobacco that cannot be sold in California anymore because our office has removed the brands from the California Tobacco Directory. As you know, under the Tobacco Directory law, only
Mr. Chairman, I
brands...
move the bill.
The bill's been moved and seconded. Thank you. Thank you very much for your testimony. That's very helpful. Any other witnesses, please try to not repeat what's already been provided, if you can, sir.
Yeah, promise. Paul Nepreth on behalf of the American Lung Association California. We're pleased to support the bill.
Thank you. Any other witnesses in support? Any testimony in opposition? Is there any testimony in opposition? Members, any questions? Yes, Assemblymember Nastandi.
Thank you, Mr. Chair. To the gentleman on the end, I'm sorry I didn't get your name.
My name's Bill.
Okay. First question is, shouldn't this be looked at on a congressional level? Because I assume many states had these agreements, and so I assume it's happening. Many different states have the same issue then besides California. Is that the case or not?
No. The states are sponsoring similar legislation. Similar legislation's already passed in Virginia, Oklahoma, and a number of other states. It helps us protect our ability to diligently enforce the Master Settlement Agreement and the NPM escrow statute.
But going back for a second, if I can, certain companies signed the MSA, correct? It was certain companies signed the MSA?
Yes.
And the ones that... So just so I'm trying to understand this, so if they reconstituted themselves as a different company, what did they do with their assets and everything from the previous company then? To get around this, what happens to the other company?
Really, there's a tobacco company that's behind the entire scheme, and that tobacco company is the company that's actually making the cigarettes. But what it does is it creates these sham corporations that really don't exist. And when it makes that tobacco company that's behind the scheme makes the new brand and sells the new brand for about a year usually, because escrow deposits are due only usually in April of the year after the year of sale. So what happens is at that point in time is when we finally figure out that no deposit's going to be made, and the corporation actually turns out to be a sham tobacco company,
what
a sham
happened
corporation.
to that previous company, though? Are they still making their payments? So Company A signed
There is no
agreement.
company in existence in reality. The company that's behind the scheme still exists and has all the money.
But say Company A signed the agreement, the MSA, so they have to make payments. Now you're saying they created another company to get around those payments. What happens to Company A? Are they still making payments, or do they dissolve, or what happens?
This may be where the fundamental misunderstanding is. We're talking about companies that did not sign the MSA. These are non-participating manufacturers who exist outside of the agreement with the major tobacco companies. Often they're foreign companies that we don't have control.
Okay, so they never signed the agreement.
That's correct.
Okay, that's what I was trying to understand. So if they never signed the agreement, then how are they legally bound to make payments then?
Well, they're bound by and this is part of the construct under the MSA, is that they are bound by the individual state statutes that govern non-participating manufacturers.
Okay, so they have to pay regardless, and if they're now selling cigarettes.
That's right. This bill would not subject non-participating manufacturers to new payments. It would just allow us to enforce what they're required to pay under existing law, a state law.
Other questions, members? Yes, Assemblymember Blakesley, followed by Assemblymember Tran.
Two basic questions. The first, could you help me understand in your example you cited with the Chinese National Tobacco Company that was ignoring our laws and claiming that we didn't have jurisdiction, how specifically would this modify their behavior? I think you mentioned certain evidence being admissible, and also is it a $50,000 bond and or 5% of revenue? Can you help me understand what the hammer is, or what the enforcement mechanism is for a national?
Basically, what it requires is that companies that wish to sell cigarettes in California apply to be listed on the California Tobacco Directory, and as part of that application to be listed, they have to waive sovereign immunity defenses. They have to consent to the jurisdiction of the California courts. And those are among the major items that would address that situation.
And that's in this legislation,
yes.
that waiver of sovereign standing. Okay.
Yeah.
A second question. I'm a little concerned not about the main purpose of the bill, but what appears to be an expansion of the definition of what constitutes a cigarette. On pages 12 and on pages 11, there's a more expanded definition of a cigarette, which, as I understand it, could potentially capture other products. Could you, maybe the author could speak to that issue as to whether or not you plan on leaving this amended language in the bill, or if it potentially may be coming out?
The amendment language is being prepared today, so we're going to resolve that issue.
Okay, very good. With that, I'll be supporting the legislation.
Thank you.
That will be amended in judiciary, is my understanding. Yes, Assemblymember Tran.
Thank you, Mr. Chairman. Assemblyman Nava, I don't have issues with what the Attorney General is doing. I do have an issue on the expansion of the definition, and also including tobacco. I'm a cigar smoker, and I know that there are huge fundamental differences from a personal level between cigarettes and cigars.
Right.
And I'd like you to address this head on why there are oppositions, by the way.
And the opposition, you notice, came in April 12th, and unfortunately Mr. Smith didn't get the memo and wasn't involved in the 4 or 5 meetings that my staff has had with stakeholders and the numerous meetings that DOJ has had with stakeholders. And so it's unfortunate that he chose to submit this without having any information at all. The amendment that's being proposed addresses exactly what you're talking about.
And exactly what does it do?
It eliminates the definition that would incorporate cigars.
Incorporate cigars. When will this be heard in judiciary again?
I don't know. Next week.
Next week? Because I sit on that committee as well. So
see, there you go.
We'll see it there.
Pull off on this. All right, thank you.
So I know better than to try to pull the wool over your eyes.
Seeing no other questions, we do have a motion, do pass and refer to Assembly Judiciary Committee. Would you like to close, Assemblymember Nava?
Just ask for an aye vote.
All right, members, please call. Madam Secretary, please call the roll.
Cotto.
Cotto, aye.
Anderson. Blakesley. Aye. Blakesley, aye. Chesbro. Chesbro, aye. Cook.
No.
Cook, no. De Leon. Evans. Galgiani. Galgiani, aye. Hall. Hernandez. Aye. Hernandez, aye. Hill. Aye. Hill, aye. Jeffries.
Off. I want to see if he tries to pull the wool over my eyes.
Lou. Ma. Ma, aye. Mendoza. Nastandi. Perez. Perez, aye. Portantino. Silva. Silva, no. Torres. Torres, aye. Tarico. Tran.
Your bill is on call. We have how many votes? 9. He needs 3 more votes.
See, Mr. Jeffries, you could help this along here.
Thank you, Mr. Nava.
Thank you very much.
All right, members.
There's no sheep over here, Mr. Nava.
The next item, members, is item number 1, AB 1598 by Assemblymember Bell, alcohol beverages, caffeinated malt beverages. Jim, thank you for being here.
Mr. Chairman, with your permission, we'll distribute some exhibits for you to look at. No, you cannot. Okay. Mr. Chairman?
Please proceed, Mr.
Mr. Chair and members, first, let me begin by assuring you that I'm working with the Small Brewers Association to address their concern about minor content caffeinated beverages, and I'm confident we will reach an agreement, so we are working with them, and I think it can be resolved. I've also agreed to delete some language at the request of Anheuser-Busch, and we have those amendments ready in the future. We don't have them today, though. That being said, I'll open on the bill. The bill, AB 1598, bans in California, which is universally recognized as a dangerous beverage. The science is very clear on this matter, and I'll let the experts speak to it. These beverages are so dangerous that the attorney generals in 28 states, including California's, want them removed from the market. Anheuser-Busch, Miller, and Coors, the leading producers and sellers of these products, have voluntarily banned themselves from producing and selling them. And let me say that again. They have voluntarily banned their products, not only in California, but in the entire United States of America. Unfortunately, in their absence, others have entered the market to fill the void that they left. Others not as reasonable or caring about their customers as Anheuser-Busch and Miller Coors. Others more caring about the money they make at everybody else's expense. They make claims that is it okay to mix alcohol and an energy drink separately, so why shouldn't they be able to pre-mix for consumers? How much sense does it make to you to take that dangerous combination and make it easier for everybody to get it? We all supported making the ingredients to make meth harder to get. Why wouldn't we think it's okay to allow these manufacturers to make it easier to get what we already know is a dangerous combination? They also say a ban is too big a step, and the FDA is investigating the safety of adding stimulants to alcohol. I already mentioned the two biggest manufacturers of these products voluntarily ban themselves nationwide because they recognize that it would be a dangerous nature of them. And how can this be going too far for the others? And the FDA is not investigating. It told them to prove their products are safe. We already know they aren't, but they will want us to wait until the federal government catches up with Anheuser-Busch, Miller Coors, and the attorney generals of 28 states and the great state of California. In closing, we all know these specific products are dangerous and have no legitimate role in the marketplace. If they don't do the right thing, like Anheuser-Busch, Miller, and Coors, then it's our responsibility and obligation to do that for them. And I urge that I vote. We have some witnesses, Mr. Chairman.
Thank you very much, Mr. Bell. First witness, please. Yes.
Hello. My name is Sarah Mart, Research and Policy Manager at Marin Institute. We strongly support AB 1598. This issue is not new, nor is this bill traditional. Rather, it's long overdue. In 2007, Marin Institute released the report, Alcohol, Energy Drinks, and Youth, A Dangerous Mix. 3 years later, the makers of caffeinated alcohol still ignore the public health emergency they cause. They will tell you their products are safe and not targeted to youth. They will ask you to wait for federal action while the safety of California drinkers remains at risk. They will not explain why the two biggest producers of these drinks agreed to stop making them in 2008. Now, smaller companies add high amounts of caffeine to 23.5-ounce cans of 12% alcohol, the equivalent of 5 standard drinks. Today's products are even more dangerous than the ones Miller Coors and Anheuser-Busch InBev took off the market. Producers claim their drinks contain no more caffeine than soft drinks. What they won't say is that no level of caffeine added to alcohol is generally recognized as safe, according to the FDA or any other regulatory or scientific body. The research is clear. Alcohol plus stimulants is a dangerous combination. Youth who drink caffeinated alcohol drink more and get drunk more often. They are at twice the risk of alcohol-related problems, including riding with a drunk driver, injuries, including injuries needing medical treatment, and sexual violence. Caffeine makes people feel sober while their blood alcohol levels rise. These products make drinkers think that they are safe while increasing their risk of getting hurt. In addition to the scientific research already available, there's overwhelming evidence that caffeinated alcohol is not responsibly marketed to adults. Research shows youth who combine energy drinks with alcohol do so in order to hide alcohol's flavor, to stay awake longer, and to drink more. Drinks like Four Loko and Jose hide the taste of alcohol with flavors like watermelon and fruit punch, orange blend, and cranberry lemonade. Producers also use kid-friendly tactics such as bright colors, popular music, costume and talent contests, free downloads, Facebook, and YouTube to sell caffeinated alcohol, along with the sweet flavors in their products. Making it hard for drinkers to tell if they've reached their limit is indefensible. We urge you to vote yes on AB 1598 and get these drinks off the market once and for all. Thank you for your leadership on this important matter.
Thank you. Next, please.
Mr. Chair, members of the committee, my name is John Lovell, and I'm here on behalf of the California Police Chiefs Association and the California Narcotic Officers Association. We're concerned about this issue on several levels. First of all, let's not kid ourselves. These are products that are aggressively marketed to young people. I had my assistant call around to all of the various bars in downtown Sacramento, the Hyatt, the Chops. You don't get those at any place where adults congregate. These are sold to make it easily accessible to kids. They're marketed to kids. The second level, though, that I want to mention is that this is fundamentally an officer safety issue for us. 2/3 of the domestic violence calls we get are what are called alcohol involved. DUI cases are all alcohol involved. Here we're looking at a product that not only intoxicates the person but amps them up, and that results in very aggressive contacts with law enforcement officers. We have had officers injured in these kinds of contacts, and we are in strong support of this bill. Thank you.
Ms. Assemblymember Ma, did you want to ask? Pardon me?
That's some more. Yeah.
No, not. No. I had a couple more people to testify. Then I'll call on you. Try now, please, not to repeat any of the previous testimony, if you can, please.
Committee members. My name is Francesca Gessner, and I'm here on behalf of San Francisco City Attorney Dennis Herrera to urge you to vote in favor of 1598. Scientists, doctors, and law enforcement officials alike agree that alcoholic energy drinks pose serious health and safety risks for consumers, particularly youth. As a result, the San Francisco City Attorney, along with attorneys general from across the country, have been working for over 2 years to remove alcoholic energy drinks from the marketplace. In 2008, over a dozen attorneys general, including from California, Illinois, Ohio, and New York, worked to get the two biggest players in this market, Miller Coors and Anheuser-Busch, to stop making these dangerous products. As a result, both Miller Coors and Anheuser-Busch entered voluntary agreements to stop producing alcoholic energy drinks. Unfortunately, the market void resulting from those two agreements is being filled by new products with even higher levels of caffeine and higher levels of alcohol. Sold in whopping 23.5-ounce cans, they are rapidly gaining notoriety, market share, and popularity with young people. Recently, the city attorney, along with 18 state attorneys general and top scientific experts in the field, brought these safety concerns to the FDA. The FDA took immediate action to order 30 manufacturers to provide scientific evidence that their products are safe. Under the FDA law, manufacturers have the burden of proving that their products are generally recognized as safe, and they must show that their product is safe before putting it on the market. To date, the manufacturers have not submitted any scientific evidence to support their claim that their products are safe. To the contrary, the only scientific studies on this topic demonstrate that these drinks pose serious safety risks. There is no level of caffeine for use in alcohol that has been established as safe. The science simply is not out there. In sum, governmental officials at all levels, local, state, and federal, are gravely concerned about the dangers posed by these products. And given the serious public health concerns that are at stake, we should not have to go after each manufacturer in a piecemeal fashion through separate law enforcement investigations. The city attorney urges the legislature to step in and do that which law enforcement officials cannot do on their own. Remove these dangerous products from the marketplace once and for all and protect consumers and young people in this state. Thank you.
Next witness, please. Again, try not to repeat what's already been stated if you can.
All right. My name is Paul Encia, and I'm from San Diego Youth Council. I do not drink alcohol, though I'm not against it. It's a personal choice, to each his own. One thing I'm against is the alcohol industry, who tries to recruit and trick young people to start drinking and maybe later on become alcoholics. Even though I'm young, I'm only 18 years old, I can read between the lines and I can see what this industry is doing. It's all about profit. It's all about the money. One out of two of these alcoholic energy drinks end up in the hands of the youth. These drinks are nothing but a marketing scheme through which they try to introduce alcohol to the young people. 2 out of 3 alcoholics started drinking in high school. That's a very young age. And these drinks are a perfect stepping stone for the youth to start drinking because they have very flashy looks, sweet flavors, and also they have these websites such as the Juice website where they have rappers singing about, gotta have that juice in my system. That's clearly targeted to the youth. The alcohol industry tries to glamorize drinking, tries to make it look cool so the young people will follow it. They're not selling us those drinks because they care about us or want us to have a good time at a party. It's all about profit. It's because they want us to start drinking at a very young age, start to like it, because we like it so much, maybe later on become alcoholics. It's all about profit. The alcoholics represent their ultimate means for profit, therefore they try everything they can to get people, especially us young people, to start drinking at a young age.
Thank you.
Therefore, I'm here today to to politely ask you to support and vote yes on AB 1598. As you know, voting yes on AB 1598 is the most perfect and clear way to show that you care about and that you try to protect the youth community.
Thank you very, very much. Next, again, please try not to repeat what's already been stated, please.
Hi, my name is Cassandra Kaufman. I'm 21 years old, and I currently go to City College in San Francisco. I represent the Tenderloin, the Mission community, a lot of low-income communities in San Francisco, and I'm here representing the youth voice and opinion. I have friends from all walks of life, 16 to 23 years old. Most, if not everyone I know, drinks alcoholic energy drinks, but mostly Four Locos because of its taste. You know, it tastes like soda, is very cheap and effective way to get drunk. In San Francisco, most young people call it liquid crack because of its effects and how cheap it is. It is very easy to get in low-income communities, at least where I come from, and that's where I feel is the most popular. A lot of my friends went from drinking Sparks to Four Locos. It's the new social drink amongst most of my friends. When my friends drink 1 can or 2 cans of Four Locos, most of them get sick, start throwing up. You know, some of them black out. We hang out at Dolores Park, Golden Gate Park, San Francisco. You can see them during the day, drunk, passed out because of the high content of caffeine and alcohol. And that's what I think. Alcohol companies, I feel, indirectly market this to youth by the packaging, the price, the flavor. That's why we, the youth, are its biggest consumers. I feel you can't just repackage drinks like this because youth will just go and look for the next cheapest, most effective way to get drunk. You know, a lot of the youth in high school would start off maybe drinking 40 ounces. Four Locos, 23 ounces, gets you drunk a lot faster. And so these high school students are choosing to drink this because it is cheaper than a 40 ounce. 40 ounces, $2.75, you know, Four Locos, like $2.45. So just like to finish what I have to say, you can't tell, you know, it's alcohol when people walk around the street, the packaging, the color, everything, it looks like energy drinks. Cops can't tell, parents can't tell, you know, unless you're really familiar with these drinks. And that's why I'm in favor for AB 1598 because it is indirectly marketed towards youth. And like I said, most, if not all of my friends have drank or are still drinking this.
Thank you very much. Any other, could we, how many more people do we have to testify? Is this it? We'd like to ask you from this point on, if we can, Assemblymember Bell, to ask the witnesses to identify themselves and state their position on the bill. Sure. Because we've already had 5 people testify. Could you just identify yourself and your position on the bill, please?
Sure, Mark LeBeau, California Rural Indian Health Board. And, you know, it appears that AB 1598 would be helpful in helping Native youth in California to, you know, not participate in gaining access to that particular product. Thank you.
Thank you very much. Please identify yourself and your position on the bill, please.
Hi, my name is Alexa Pasqualini. I live in Daly City, and I'm with the Youth Leadership Institute, and I am a senior at Oceana High School. I see many of my friends and peers abuse the use of alcoholic energy drinks on a daily basis. And me being one of the eldest in my family, I wouldn't want my younger family members to get a hold of this. Alcoholic energy drinks contain up to 12% alcohol. That is much more than the average beer. And if a beer can easily intoxicate an adult, imagine the damage an alcoholic energy drink can cause.
Thank you. Please, again, identify yourself and your position on the bill. Next.
Hi, my name is Marcela Araujo. I am from Daly City. I am a senior at Oceana High School. It is not healthy and it is harming everyone around us, especially youth who may think alcoholic energy drinks are fun and taste just like soda. Then when the consequences come, who are we to blame? This is embarrassing and we should all be ashamed of ourselves. How would you feel if your own 15-year-old daughter or my best friend was drinking a juice and someone found her on your neighborhood in the middle of the night passed out?
Thank you very, very much for that testimony. Anyone else, would you please just identify yourself and your position on the bill, please?
Mr. Chair, Member Fred Jones, California Council on Alcohol Problems.
Thank you.
Matt Rosen, Youth Leadership Institute.
For the bill.
Support for the bill, okay.
Andrew Keller from Governmental Solutions Group. On behalf of San Francisco Unified School District, we stand in support of this bill.
Support of the bill. Any other testimony? Are there any witnesses or any testimony in opposition to this bill, please? Please step forward.
Here they come.
Give some room.
Yeah.
Thank you. Please identify yourself and state your position.
My name is Jeff Wright. I am CEO of Fusion Projects, the makers of Four Loko, and I am opposed to this bill.
Matt Dornauer, General Counsel for Fusion Projects, in opposition to AB 1598.
Jason Freeman, President, Fusion Projects, opposition.
Good morning, Assembly members. My name is Jeff Wright. I am CEO and one of the founders of Fusion Projects, LLC, manufacturer of the Four line of caffeinated malt beverages. With me today is Jason Freeman, who is president and also one of the founders, and Matt Dornauer, who is our legal counsel from Sidley Austin, LLP. We are opposed to AB 1598, a bill seeking to take the unprecedented step of prohibiting the sale of any caffeinated or stimulant-enhanced malt beverages in California, which would effectively put us out of business and eliminate many jobs in the state. We started our business in 2005 by taking out an SBA loan and putting our personal finances on the line. Through hard work, perseverance, we have become a nationally respected alcoholic beverage company, selling our federally and state-approved products in 40 states. We have 60 employees nationwide, including 12 right here in the state of California. California is a vital part of our success, and if enacted, AB 1598 will severely harm our small business, our employees, our distributors, and our retailers throughout the state. This bill would also be harmful to California's economy because it would deprive the state of millions of dollars in tax revenue generated from retail sales tax, as well as excise tax on our products. We recognize there are serious concerns regarding the misuse of alcohol in our society. Alcohol abuse, drunk driving, underage drinking are all problems we would like to see solved. It is naive and unrealistic to believe that these problems will be solved or addressed effectively through prohibition. Our products have been consumed safely and responsibly by adults over the age of 21, and we have a vested interest and assuring the continued responsibility consumption of our products. We are opposed to AB 1598 for the following reasons. First, the FDA is presently reviewing whether combining caffeine with alcohol presents safety concerns. The current behavioral studies offered in support of AB 1598 are insufficient to support the proposed ban. In fact, the main study cited by the proponents admits that it contains various limitations and concludes that further research is necessary. To the extent there are unanswered questions regarding the effects of consuming our products, the pending FDA review should answer those questions. The FDA review began when they sent a letter to our company and to about 30 other companies that manufacture caffeinated alcoholic beverages, requesting these companies provide their rationale and supporting data for concluding that adding caffeine to an alcoholic beverage is safe. In response to the FDA's letter, we informed the FDA that we would prepare on an expedited basis a GRAS, generally recognized as safe notification for caffeine and alcohol. Our GRAS review of caffeine and alcohol products is almost complete. We expect to submit the GRAS notification to the agency this month. The information contained in the GRAS notification and the FDA's follow-up and determination by the agency's independent scientists would be extremely relevant to deciding whether legislation such as AB 1598 is necessary for the protection of California citizens. Even the Marin Institute, co-sponsor of this bill, in a November 2009 press release, praised the FDA for undertaking this inquiry. We believe any action by the Assembly, particularly actions that involve outright prohibition, prior to this scientific evaluation would be premature. Therefore, we urge the committee to delay its decisions regarding AB 1598 until the studies being prepared for the FDA are available for review by you and the rest of your Assembly.
Thank you. Please proceed.
Yes, Jason Freeman again, President, Fusion Projects. Just wanted to point out a couple other things. We have never marketed our products to minors. None of our point-of-sale material, none of our websites, none of our packaging has ever been intended to market to minors. And with respect to the settlement agreement with AB and Miller Coors, their settlement agreement was not based on the product. It was based on their marketing practices. And that is something that we do not do, and it's not something that we plan on doing in the future. As a responsible member of the Alcohol Beverage Committee, I know the proponents of this bill had passed out some props up there, and I believe one of our products is up there. Prominently on our can, we have in bold capital letters, contains alcohol, flavored malt liquor, premium malt beverage, 12% alcohol by volume, and We ID stickers on every single can and product that we have. So it's very clear to retailers, to consumers, what the product is and what they're getting. And we want this to be one of our reinforce our message that our products are only sold to legal adult drinking age. None of our marketing materials contain any statements or graphics directed to or to attract minors. In fact, in a recent correspondence with the California Department of Alcoholic Beverage Control, they acknowledge that they do not have any definitive information indicating that caffeinated malt beverages are sold to minors at a rate any higher than any alcoholic products. Now, this is straight from the California Department of Alcoholic Beverage Control. There's no distinction there that these products are sold more to minors than any other alcoholic products.
Thank you very much. Mr. Norwood?
Yeah, Mr. Chairman, members, John Norwood on behalf of United Brands Company. United Brands is a malt liquor producer based in San Diego, California. You've heard a lot of testimony on this bill, so I'm going to be very brief. Simply, this bill is premature. The supporting material for the bill, much of the testimony you've heard, some of the studies that you've looked at go to the issue of caffeine as an ingredient in alcoholic beverages, not caffeine as an ingredient in malt liquor. This bill targets only one of the many and numerous ways that people can combine caffeine and alcohol products. As indicated, the FDA is looking at that issue. We're active in that issue. It'd be premature to institute a ban on this product prior to that. For those reasons, we're opposed to the bill and ask for your no vote.
Thank you. Mr. Latimer.
Mr. Chairman and members, John Latimer on behalf of Diageo. We submitted, and I apologize to the author and the committee, an opposed unless amended letter on Friday. I've had a number of conversations with the author's office about this bill. I think our concern generally, while we don't have any products currently in this space utilizing caffeine, we certainly have in the past. And it's an overly broad statement, we feel, to say that any amount of caffeine or any amount of additive, which the bill effectively says, combined with alcohol, it, causes the types of harms that the author and the proponents would describe. I understand that they don't believe that any amount of alcohol and caffeine combination is safe. Then, frankly, they ought to wait to allow the science to determine that point before they ban every and all combination of alcohol and caffeine. As all of us know, the concept of alcohol and caffeine coming from legitimate flavorings has been around for a very, very long time, be that rum and Coke, Baileys and coffee, Irish coffees, etc. As what we take away from listening to the concerns of the author and the proponents, it sounds like much more of a debate about packaging, and it's much more of a debate about marketing and promotion. We certainly don't, in terms of Diageo, condone promoting an alcoholic beverage as having energizing or stimulating effect, and suggested to the author that perhaps that's a more effective way to go to target companies and products that are looking to promote their product as having that effect. That's not a practice that Diageo engages in. But to, again, throw out all flavoring agents that may have any amount of caffeine or ginseng or taurine or any other additive in it, we think, again, is going too far, certainly ahead of the science.
Thank you.
With that, get to a
Thank you very, very much. Any other, if there's no other testimony in opposition, we had a couple of questions, or do we have any questions? Members of the board, members of the committee, any questions? Yes, Assemblymember Blakesley.
Yeah.
As can be contained in soda pop, 200 million parts per.
Yeah, it's 200 parts per million. It's about 70 milligrams of caffeine per 12-ounce can.
Okay, and a follow-up question. Earlier this week, I had a nice dinner of pasta and a glass of wine. I'll claim it was only one glass of wine, and finished up with a cup of espresso for dinner, for sort of after-dinner coffee drink. I'm trying to understand the assertion that this constitutes a public health emergency. Is the author or the author's witnesses asserting that there's a physical a health problem, or is it the behaviors that subsequently potentially ensue that constitutes the hazard? Just so I can be clear, I mean, is that glass of wine and then after dinner espresso dangerous as well?
We feel the same way. It's a distinction without a difference.
I think.
Oh, I'm sorry.
The question is for the author, Mr. Bell.
Yeah, I think we heard testimony today from law enforcement and testimony that there is a safety issue. And we heard testimony from young people that there is a safety issue for our young people, and we heard testimony from our law enforcement that there is a safety issue. Drinking and using caffeinated beverages is a dangerous thing, and it was interesting that nobody opposing the bill actually spoke to the safety issue. Nobody spoke to it. And one thing I like to point out is that you can see by the prices on there, the ones that have alcohol in them are cheaper than the ones that don't. So you have an energy drink with alcohol, it's cheaper than the ones that don't have alcohol. That's why the Attorney Generals took action.
Thank you.
That's why they think it's a safety issue.
Mr. Blakesley, one more question, then I think Mr. Perez has a question. Yes.
And just in wrapping up, I wanted to get a little more clarification about the assertion that no marketing was being done to minors. What steps have you taken to ensure that minors are not being drawn to this type of product? We heard about a website which features rap music and bright colors and a lot of sort of elements of our advertising program that I would, maybe infer might be for teenagers. Can you help me understand how do you make that assertion that you're not marketing to teenagers?
Well, we are a small business that obviously started basically with the savings of the two of us. And we don't have the $100 billion advertising budgets that major companies have. So we don't do any print, we don't do any television, we don't do any of the major advertising mediums that are out there. What we do, and this enhances our position, is point-of-sale material. Posters, stickers, and all of our stuff says contains alcohol, you must be 21, no loco, no ID is something that we put on all the cooler doors in the convenience stores, and just to educate all our distributors and retailers about where our product should be, what it should be done, and who it should be sold to.
I'll just finish up, and thank you for the chair's
Please
indulgence.
proceed.
I really appreciate it.
Please proceed.
I'm not inclined to support this legislation with the absence of more information about the health effects, but I am concerned that there may be a problem in marketing. And the testimony I heard I thought was fairly compelling, that young people are being drawn to this product, and I would encourage this startup business to look very seriously at their marketing practices, because I think the next step might be legislation to crack down on such marketing.
Assemblymember Perez had a question.
Thank you, Chairman Cotto. I've had the opportunity to read a little bit of information on this, and I'm still trying to get some more understanding. I don't know where I'm at on this issue up to this point, but I am concerned, obviously, when I'm hearing from youth as to how accessible these drinks really are. And at the same time, on the other side, obviously, I want to encourage entrepreneurs, young entrepreneurs, especially during our tough economic times, and starting up a business. I'd love to see you flourish and to succeed. But obviously, we have to have a balance between profit and quality of life. And so my question here has to do a little bit with pertaining to our youth and how it is that they're even accessing these drinks. I read it here. It does say we ID, right? It does say it contains alcohol. But at the end of the day, and I don't know if this is a question for yourselves or for the supporters of this bill, but how is it that students, even though it states here we ID and it says there that there's alcohol in the can, how do they get into it?
Mr. Chairman, I'd like to have our district attorney
please
respond.
Francesca Gessner from the San Francisco City Attorney's Office. Because the can, and I believe you have cans of both the alcoholic energy drinks as well as I think there's an example of a non-alcoholic energy drink up there, Rockstar. You see the cans are very similar, the size, the graphics, the colors. We've, in our investigation, come across evidence that store clerks, since these are being sold at 7-Elevens and convenience stores, often mistake these for non-alcoholic energy drinks. So that has made it easier for youth to access them as opposed to other types of alcoholic beverages.
So a follow-up question with that. Where are they being placed in the store? Are they within the alcohol section, or are they, I don't know, in the Gatorade section?
Mr. Perez,
if I
may
if I can respond to that question.
May I respond to the question?
There is state and
Sure, whoever would like to respond to the question.
state and federal law requires these beverages be put in the adult beverage section of stores. It requires the labeling of alcohol content and that they contain alcohol. There cannot be any type of marketing with energy or energy inducing type of implications on those. They're separated from other products, oftentimes store clerks, and these I actually went to a liquor store the other night, and the store clerks do know the difference. They have a list. Sometimes their computer systems tell them when to ID certain products that come up on as they're rang up, so there is a distinct difference.
In regards to the 7-Elevens, a lot of the major convenience stores, C-store channels, whenever they scan a product, they take the barcode, and as soon as it scans, something pops up on their screen that says, you must ID this customer. So I don't see how underage students could be going to a 7-Eleven and buying the product.
Thank you. Clarifies it. We have Mr.
Yeah, kids don't go into stores and buy alcohol, right?
Right.
That's my answer.
Hold on a second, please.
Then who does?
Wait a second, please. We have a question or comment from Vice Chair Jeffries, and then Mr. Tran, please.
I just want to applaud the author for his efforts to try and keep minors from accessing alcohol. I think that's an effort that all of us should follow your lead on. I mean, I really do appreciate your efforts on that. I'd never encourage my kids to drink any of this kind of material, and you know, when they're adults, they can go skydiving and bungee jumping and all those things that they want to do, but that's their choice as an adult. So I do appreciate the issue of marketing concerns. I do respect your efforts to push back on the efforts to make this more attractive to minors. That is a valuable effort on your part. I cannot, however, subscribe to the theory today that the mixture of caffeine and alcohol is inherently dangerous to all Americans. And if it is, for argument's sake, assume for the moment that it is inherently dangerous, why then would we only select one particular product or marketing group and allow all others to continue to proceed with whiskey and Coke and Kahlua and vodka and rum and Coke and say that that mixture of caffeine and alcohol is quite acceptable and there are no health problems? So I think the effort here today, and just to wrap it up, is a good one to address, again, the issue of minors getting their hands on this material. The scientific data, however, does not appear to support the conclusion that caffeine and alcohol is inherently dangerous for all Americans. So I think until we have some sort of verifiable, independent, third-party studies that the FDA is going to respect and our own community of scientists in our state are going to respect, I don't know how this committee could take a position that one particular brand of caffeine and alcohol is going to be dangerous while another mixture is not. We're not in a position as a committee, at least in my opinion, to make that distinction today, and so I would encourage you to rework this and come back with something addressing the marketing issue.
Mr. Tran, please.
Thank you, Mr. Chairman. I second what Mr. Jeffrey said. I understand the objective, but I think it's easy to confuse and obfuscate the issue. On the one hand, you have issues related to advertising, labeling, enforcement of existing laws on the books against minors drinking and purchasing alcohol. On the other hand, you have health risk issues if you're going to mix alcohol with caffeine, and to my understanding, that's still up in the air. The verdict's still out on that. Unless, and I'd like to hear comments real quickly on the part of the panel, both the author as well as the opponents, as to where we are with the FDA study and where we're going on this. Because
we can
reading,
to that.
yes, reading what we have here, it's again, the jury's still out on the health risk.
Again, we don't want to replay all the testimony. Right. Where are we with the FDA and their study? And we'll ask you, and then we'll ask the sponsor, please, or the author.
We are in the process of submitting the study to the FDA this month. We have been in constant communication with the FDA. They've been abreast of the situation, and they have had no qualms with it, with us getting on this study in this timely manner that we've done. And we are confident that the study will be deemed GRAS, generally recognized as safe. And we ask, as you alluded to, that instead of judging us guilty until proven innocent, that we wait until the FDA gives us a definitive answer.
No editorial comment, just the answer to the question. Mr. Bell, please.
I'll have our
like to
attorney
respond?
answer that question, Mr.
Sure.
Chairman.
Ask the attorney answer the question. Status of the FDA.
The FDA investigation may take months or even a year to complete. We do not know how long it will take them, but they have made clear that the burden to prove safety is on the manufacturer. It is not to prove that it's unsafe. They must affirmatively prove that it is safe, and they have not put forward any evidence that it is safe, and there are third-party independent studies in peer-reviewed journals establishing that they pose safety problems.
Thank you.
That's the only evidence we have right now.
We have one more.
Thank you, Mr. Chairman.
Thank you. We have one more question by Mr. Liu, and then I'm going to call for a motion if we can. Mr. Liu?
Based on their committee analysis, my understanding is that a additive is presumed to be unsafe unless FDA has specifically authorized its use. And my understanding is that FDA has not authorized caffeine at any level in alcoholic beverages. I just want to say I'm reading that law correctly, and that as of right now, these products by the FDA are presumed unsafe until such a second determination is made.
That's still an open issue, Assemblyman Liu.
Quickly. Wait till you
May I answer the question? I'm sorry.
Very quickly.
That's still an open issue. We received a FOIA response from the FDA and from TTB indicating correspondence going back and forth for a number of years since 2001 in which they were unclear as to whether or not caffeine and alcohol needed to be regulated by the FDA. Therefore, there was a 200 parts per million number limit given as a benchmark.
Thank you.
And that's what we have been following.
One more brief comment, please.
Liu described it as the correct standard, and the 200 parts per million, the FDA has said that is for cola-type beverages, and that is not the standard for alcoholic beverages.
Members, we've had plenty of testimony and questions on this. The bill is before you. Is there a motion? And then I'm going to ask him to close after we get a motion, I think, don't you think? Yeah. Do we have a motion? Is there a motion? Bill's been moved by Liu. Do we have a second?
I'll give it a second.
Second, courtesy second.
As a courtesy vote, but I think we need to have more discussion.
Courtesy second. Could we have, Mr. Bell, would you like to close?
Yeah. When the FDA establishes standards, they establish standards, and they have officially decided that they are going to investigate this and determine what the safety levels are. And you should not put caffeinated beverages with alcohol until that standard is developed. We have no idea when they will develop that. And it is my position that we have received evidences of other studies and plenty of other studies that indicate that this beverage should not be allowed on the market, should be banned, and that we will work with the association at the next levels and the manufacturers at the next level to clarify the Small Brewers Association's concerns, which is essentially their concern is very minute amount of flavoring additives that would add to the drinks to allow some flavoring. So we will work with them on that. But you heard the testimony. You heard the young man who told you that they're saying you got to have the juice in my system. If that isn't advertising to young people, I don't know what is. These beverages and other companies are targeting young people, and we can't stick our head in the sand. We have to do something about it. I urge and I vote.
Thank you. Thank you very much for your closing. Members, you've heard there's a motion to approve the bill. Please call the roll.
Cotto?
Cotto, aye.
Anderson? Blakesley? No. Blakesley, no. Chesbro? No. Chesbro, no. Cook?
No.
Cook, no. De Leon? Evans? Galgiani? Hall? Hernandez? Hill? No. Hill, no. Jeffries? No. Jeffries, no. Liu? Aye. Lou, aye. Ma. Mendoza. Nastandi. No. Nastandi, no. Perez.
Aye.
Perez, aye. Portantino. Silva. No. Silva, no. Torres. No. Torres, no. Tarico. Tran. No. Tran, no. That bill has 3 votes.
Is that correct, Ed? Not voting? Not voting. So what's the?
You have 3.
Pardon me?
You have 3.
You have 3. You need 9 votes. So we're going to put it on call. Thank you, Mr. Bell, for your presentation. Next presenter is Mr. Blumenfield, AB 2756. Mr. Chairman, take care of this while I go to the...
Very good.
Chair.
Acting,
For the chair.
acting vice chair, acting chair.
Acting vice chair, acting chair. Excellent. Thank you, Mr. Acting.
Please proceed.
I rise today in support of AB 2756. You all know about spam on your email. Well, sad news is that spam has crossed the virtual boundary and is now in our neighborhoods. I'm talking about road spam. This is a problem that is plaguing my neighborhood. It's funny if it wasn't so serious. I mean, we have these unhitched trailers are popping up everywhere like unwanted weeds throughout the San Fernando Valley. They advertise things like 2-hour massage parlors, what is this, a dance club, all spray-on bed liners, anything you can think of, these things are out there. And if you think that your neighborhoods are safe, they're not. A lot of great things begin in the San Fernando Valley. Unfortunately, sometimes some bad things begin here too, but it's spreading. It started in one little area on a road, and it's spread out. It's in front of people's homes, and it really is blight. There's no other word for it. It is blight in our community, and we need to get rid of it. And the way we can get rid of it, the cities have tried to get rid of it on their own. The city of LA will be here to testify. They would love to get rid of it, but because of a quirk in the law, if for them to get rid of it, they have to post signs at every intersection, every thousands of intersections along the city of LA. So what this bill does, it simply flips that presumption and says, we're going to ban these things, these ugly, unhitched trailers from our neighborhoods, unless the city wants them, and then they can make their own regulations up and they can bring them in and do whatever they want. But it flips that presumption so that cities don't have to post a sign at a very high cost at every little intersection that comes into the city, which is particularly difficult for large cities. Some small cities have been effective in doing their own bans because they can post. Like City of West Hollywood was able to post something because they only have 3 or 4 intersections. In Los Angeles, we don't have that luxury. So I ask you to help us get rid of this blight in our community and to support this bill. And I turn it over to my joint author, Mr. Fuhr.
Just very briefly, these mobile billboards are a distracting safety hazard for drivers. They are a source of blight in neighborhoods, and they take needed parking spaces that otherwise are available for commercial businesses, especially small businesses. The legislation does not require that cities and counties throughout the state of California enact such bans. It creates a statewide ban from which local jurisdictions can deviate.
Move the bill, Mr. Chair.
So both of us are here to urge that we move this legislation forward. Essentially, it allows local control in a more meaningful way over a public safety, public nuisance, source of blight, parking issue. Thank you.
Thank you. We have a motion. Do we have a second? Second. We have a second. Testimony from witnesses in support.
Thank you, Mr. Chair and members. I'll be brief. Andrew Antwi here today on behalf of the City of Los Angeles. Just to say, the authors have correctly stated that we're looking for authorization to do enforcement. We've attempted to do this on our own. That's been met with some legal challenges. Courts have ruled in our favor. We hope this bill moves forward so that there's absolute clarity that we can move forward on enforcement. I believe the City Council would like, in Los Angeles, has already taken steps to try and enact an ordinance to make it clear that these items are banned. This legislation would make it absolutely clear and allow us to do what we've attempted to do for the last 3 years. Thank you.
Additional testimony in support? Testimony in opposition?
Mr. Chair and members, Brian Moss of the California New Car Dealers Association. We had been in extensive conversations with Assemblymember Blumenfield about the bill. We're concerned that as presently drafted, there are some terms that need to be nailed down in terms of what exactly these mobile advertising billboards are. We recognize the problem, and in fact, car dealerships are as victimized as other businesses because folks park these things in front of our business advertising their products without authorization or paying the appropriate fees and what have you to the local jurisdictions that are seeking to regulate them. So we're working with Assemblymember Blumenfield. We think we can come up with definitions that make the bill tightly drafted. And so we sent an opposed letter, but we're going to work out our opposition in the future.
Very good. So we've heard from the proponents and opponents. Questions from, unless there's another opponent. Do we have another opponent?
I wanted to make sure I get a me too. This is Bruce Livingston, Executive Director of Moran Institute. We support.
Very good. Okay, questions from the committee? Start over here, Perez, and then Blakesley and Sandy.
Thank you, Mr. Chair. Just a quick question. We're not referring to mobile billboard advertising on wheels that move from location to location. Have you seen those? Do you have those as well in the San Fernando Valley?
We do. You mean the ones that are actually attached to the vehicle?
Yeah, and they're actually moving around from location to
location. That's a problem, but that's not addressed in this bill. This bill is pretty narrow, dealing with just the unhitched trailers. I don't like those things either, but those are not addressed. This doesn't, and the clarifications we're going to make with the new car dealers are making sure that it's absolutely clear. We're not talking about vehicles.
Okay.
We're talking about unhitched trailers, non-motorized, garbage that's left behind on the street.
Appreciate your point.
Blakesley
humble,
was
those
next.
are
Is that
more
the
than
A?
welcome.
Mr. Blakesley, I'm sorry, and Standy, and then Mendoza.
Mr. Chair, if I may, I think, will they be next also to the dancers on the corners? After Blumenfield and Mr. Fielder.
Please, Mr. Blakesley.
Could you clarify for me whether or not this applies only to those unhitched signs that are in public right-of-ways, or if those items are on private property, if they're on parking lots, if they're off the street, would this apply to them as well?
No, and very clearly, and it does not apply to private property. It's only on public streets. We're making some clarification language with the new car dealers to make that, put the belt and suspenders. It is, and I could say without doubt, it is my intention and Mr. Fuhrer's intention that it not have any impact on private property whatsoever. I think that's the way it reads in the bill. We're working with them to make it even more.
That would be very important to me. And secondly, it specifically references advertising. Is there any way this could potentially capture political speech or freedom of speech issues that may not pertain directly to buying or selling something, but a desire for people to communicate? Sometimes you'll go down the street here, and you'll see people with signs, out in front of the Capitol for and against certain positions. Is there a clear, bright line that would not affect the question of free speech?
There was we picked up the language from a court case in another one that was specific to commercial language. That's why we chose the language that we did on that, so that it would be absolutely clear, and the courts have ruled on that language saying it's fine to segment the commercial speech the way we have, and it does not affect political speech or other non-commercial speech.
Standy.
Thank you. Could you please clarify for me, first of all, you said Los Angeles had tried to do this, tried to ban it, and they could not. Please explain why you cannot. And then also, how can the state come in and impose this, not have to post signs or do whatever? Well, is there a different requirement that the state has in making this laws as opposed to the local government?
Thank you, Assemblyman. We've been doing enforcement in the city of Los Angeles on these trailers for about 3 years, and we'd followed the 72-hour rule. There's a section 21 of the Vehicle Code that essentially preempts local jurisdictions from doing enforcement on public right-of-ways. And we were actually sued by one company that used these hitched trailers as an additional part of their advertising campaign saying that we violated due process because of not providing secondary and third notices before an impoundment action was enforced. And so we think this legislation would actually help clarify that we do have the authority, specifically dealing with the preemption issue that is in current law.
So how can, just so I can understand, so the
Maybe
states...
I can add to it. As a state, if we ban them as a state, and then cities do what they want, if they want to allow them and regulate them, they can do that. But then they're not required, each city is not going to be required to post signs upon the entrance to the city. And it's just a state law. You don't have to post signs on the entrance to the state because people understand that there's a difference in state laws. But
yeah. I mean, let me be clear. State law at the moment has this preemptive effect. We can change state law. This bill is an attempt to make very clear that the state, in fact, it says on its face, if you read the language of the bill, it's very short, this is not an attempt by the state to occupy the field. It's an attempt to say we're going to ban this, leaving local jurisdictions the discretion to deviate from that if they wish to, which is the exact opposite of the status quo.
Right. But going back to the court case, and you said you won the first round, did you say?
That's right.
And it's on appeal?
That's right.
Because maybe you'll win on appeal also, and that will be done. No need for the law then, correct?
Our city attorney has taken a very conservative approach on this and interpreted state laws preempting what we attempted to do. And the vehicle code seems to be pretty specific on it. The advice of our city attorney, we're pursuing legislative authorization. And the truth is we're trying everything. There's already attempts at the local level to go forward and do this. We want to make sure that we have the authority in a very clear way. State law.
I think one of our jobs as legislators as well is to try to obviate the need for litigation by having clear lines drawn. And that's what this bill's about.
Mr. Mendoza.
I guess when I was on the city council, we dealt with unhitched trailers as well. We never had any problems as far as regulating them. So I'm kind of a little bit puzzled why you're having such a hard time, especially, I guess, in the legal context. So maybe I can look into that a little bit further. Why aren't there other cities in support of this bill?
the plague starts somewhere. We're ground zero. We're the first patient that's been infected, and now it's spreading. So yes, it will affect all sorts of other cities, but the disease of these things is right now it's in San Fernando Valley, but it's on its way. Without this legislation, I'm quite confident it'll be in all of your communities.
Mr. Assemblymember Torres. Assemblymember Torres.
My question was similar to Brian's in regards to rural communities. And I get it, driving to the 911 center in the valley. I mean, clearly you see traffic accident after traffic accident after traffic accident from the overnight looky-loos that couldn't keep their eye on the road because they were looking at these unsightly signs. I get that, but what about driving on the 5 freeway? How do I know that, the tomato vendor is, that's a mobile sign also, is available for me to exit at the next exit in rural areas?
Under the bill, that jurisdiction could choose to regulate them and allow them. That's the point of the bill, is that it allows for that flexibility, but it also makes it easier for those jurisdictions that want to enforce these rules to do so. But there's nothing that precludes that from happening.
Okay.
Thank you. Members, there's a motion and a second. Would you like to close, please?
I ask for your strong support.
The recommendation, by the way, is due pass to Assembly Transportation Committee. Ask for an aye vote. The author has asked for an aye vote. Please call the roll, Madam Secretary.
Cotto.
Cotto, aye.
Anderson? Blakesley? Blakesley, no. Chesbro? Chesbro, aye. Cook?
Not voting.
De Leon? De Leon, aye. Evans? Galgiani? Hall? Hernandez? Hernandez, aye. Hill? Aye. Hill, aye. Jeffries?
Off.
Liu? Ma? Mendoza? Aye. Mendoza, aye. Nastandi? Perez? Aye. Perez, aye. Portantino? Silva? No. Silva, no. Torres? Aye. Torres, aye. Tirico? Tran? Tran, no. You have 8, you need 4.
We have 8 votes, you need 4 more. All right, we're going to, after